Hello, I'm Stephen Mather, and here's what your small business needs to know about the Uber and Aslam Supreme Court decision. Today, Friday the 15th of February 2021, the Supreme Court gave its much-awaited input into a long-running legal fight between Uber and an Uber driver known as Mr Aslam. The basic question for the judges was, were Uber drivers workers or self-employed contractors? Uber has defended the matter since an Employment Tribunal a number of years ago decided that Mr Aslam was a worker and therefore he was entitled to the rights of a worker, minimum wage and holiday pay. He'd claimed that he should be paid minimum wage while working from the moment he switched on the Uber app to when he switched it off and closed it down for the day, rather than just be paid per ride given to the paying customers. Uber's position has always been that the drivers are self-employed contractors. They say that the drivers decide whether to work or not, how long to work. They have to have their own insurance, they have to have their own vehicle and cover all the vehicle costs themselves. The court's view, which is the court's previous decisions, it was agreed by the Supreme Court, the highest court in the UK, is that the drivers were in fact workers. And while I'm no QC working at the Supreme Court level, the decision stems from what I call the Spade Test. If it looks like a spade, works like a spade, it's probably a spade. I know you can do similar tests with ducks, apparently. Anyway, the nub is this. Uber, they referred the court to all the written agreements they had, their contracts with the drivers, contracts with customers, and much more besides, all of which pointed to the drivers being self-employed contractors. But the court said that's not the way to decide the answer, and instead, future courts and tribunals should look and decide on actual facts and make the decision there. So here, the Uber driver had to sign onto the app and then be available for work. And while at work, they were obliged to follow the Uber system, rules and policies. They couldn't do other work while at work. Their rate of pay was dictated by Uber and the app. They weren't able to get someone else in to do their job. And while they weren't obliged to follow Uber's route, they could be deducted fees if the customer complained it took too long. There are a number of significant performance targets and policies in place as well as Uber operating a driver disciplinary type process. There were 5 key aspects according to the court. 1, the drivers could not set the price they got paid, and Uber itself set the service charge of 20% it deducted from drivers' earnings. Number 2, the contractual terms were totally dictated by Uber. Number 3, while a driver could decide when and where to work, as soon as the driver logged onto the app, their choice was constrained, and if they rejected too many ride requests, they got sanctioned. Number 4, Uber controlled the service delivery, specifying what type of cars, what colours, their preferred route, with driver ratings to further control that. And 5, Uber restricted communications between the drivers and passengers, so a driver couldn't claim their customer as being their own. The decision then wasn't a surprise to many employment lawyers like me, but it does continue to impact on smaller businesses like yours. I've seen many small businesses try to take people on a self-employed basis in order to avoid tax and having to avoid things like holiday pay, sick pay and maternity leave, those types of things. A recent example I came across, for instance, was in relation to swimming teachers. The company suggested the teachers were self-employed, as outside of the 6 or 8 hours of teaching, they were able to do what they like, when they like, with whom they like. However, the question is, what are they doing for the 6 or whatever hours they're working for you? So if you have self-employed people working for your business, and they are not free to come and go as they like, they cannot send a replacement, you control what they do and how they do it, or you put constraints on the service delivery. If they can't decide how and when, how much to charge customers, then you may need to consider them being workers rather than self-employed consultants. So what does it mean in practice? A worker isn't an employee, so they don't get all the rights an employee gets, but they are entitled to minimum wage and paid holiday amongst some other things. For Uber, that's likely to mean claims from drivers seeking back pay of national minimum wage going back probably 6 years. For your business, it's an opportunity properly to consider whether the people you use are genuinely self-employed contractors, workers or employees. If you need help with that, then do get in touch with me. I'm Stephen Mather. I'm www.stephenmather.co.uk. Thanks for watching.